Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 248 of the NCDWI Guy podcast. On today's episode, we are continuing our conversion tactics series. We started this back on episode 245, talking about the importance of a speedy response to potential clients in increasing your conversion rate. And now we are going to move into addressing unspoken objections. Addressing unspoken objections today. So we skipped a couple of episodes. This is going to be kind of an ongoing series, but not a every week series. So we're going to have some other content in between the conversion episodes. So today we're going to talk through addressing 5 unspoken objections from your potential client. Bo Bennett, entrepreneur and author, says an objection is not a rejection. It is simply a request for more information. An objection is not a rejection. It is simply a request for more information. Now, how can you address unspoken objections? How can you address unspoken objections? How do you know these exist? Well, most of your clients have unspoken objections that they are thinking about, wondering about during and after and before the consultation. So how do you know that these objections exist? Well, it's because by some clients, they are spoken. If enough people are voicing an objection, even if it's kind of a 10% overall voice rate, you can guarantee that most of the other 90% are thinking about these objections, even if they're not asking about them. So if enough people are voicing an objection, others are thinking about it. So these 5 unspoken objections that I'm going to address are based on a pretty good percentage of clients voicing the objection. So you have to know that it exists. You have to address it, even if the potential client does not ask about it. So we're going to address 5 unspoken objections. These are not an exclusive list of unspoken objections, maybe not even the top 5, but they're ones that I frequently get with DWI consults. And so you have to address these objections. So first of all, am I going to jail? Am I going to jail? This objection is important to address early on. The jail question is important to address early on because if somebody is worried about this consequence, they will not be able to think clearly about a word you say until they know the answer to this question. So many clients, I think, have a 1-hour conversation with an attorney, 30-minute conversation with an attorney or multiple attorneys, and they retain from that consultation very minimal information because their brain is so focused on specific pieces of information that either take a long time to get addressed, that they just are ignoring all of the words coming out of your mouth because they're so worried about this one consequence, this one impact in their life that the DWI is going to have. And so I believe it's important early on to address the jail issue because I think it is a huge block point for clients to hear everything that you are going to say. And if you're going to basically explain a lot during your consultation, and that is part of your quote unquote sales pitch of, hey, let me tell you and show you how much I know about this area of law, the client is not hearing that and gaining that if they are worried about the impact, the consequence of jail time in their life and the life of their family. So, two big picture points on opposite ends of the spectrum that are important. In this regard, you don't want to fearmonger. So if somebody is not facing jail time, you need to basically eliminate that issue from the get-go as a realistic outcome of possibility. On the flip side, if somebody is potentially facing jail, they're habitual DWI, A1, level 1, then you can't sugarcoat during the consult. Don't say, oh, everything's going to be okay. This will be swept under the rug. You have to not create unnecessary fear and anxiety, but also you don't want to sugarcoat the reality of the situation that your client is facing and have them start out on the case with you with false expectations about what they are facing. So, two kind of approaches to this based on sentence level. So you've asked questions about what level they're facing, what grossly aggravating and aggravating factors, mitigating factors are present. So if you've got a level A1 to 2 client, you want to focus, or a habitual DWI, you want to focus on the ways to avoid jail. You want to lay out the scenario. Look, you are looking at a level 1 sentence. In this jurisdiction, based on everything that you've told me, it's very realistic that you would be potentially looking at the minimum end of that sentencing range, which would be 30 days or 10 days if you've got a continuous alcohol monitoring device on because you're facing a level 1. You can also potentially replace some of that jail time or all of that jail time with inpatient treatment. That is likely in this particular jurisdiction, county. That's not likely in this particular jurisdiction or county. You know better than anybody else, hopefully, what is likely to happen in the counties that you practice in. But you want to basically say, here's the realistic worst case scenario. Here's the max possible time a judge can impose. And here's the mitigation that we need to work on in order to minimize the consequences. You have to have that conversation from the get-go. You have to talk through it at the outset. On the flip side, if it's a level 3 to 5, you want to focus on trial potential as well as on mitigation. So you don't have to say you're looking at, the maximum possible punishment at a, DWI is 3 years, 36 months, right? No, if they're level 5, at a level 5, this is probably where you're going to fall. Maximum jail sentence is 60 days. Likely in your scenario, we're not looking at any jail time. Community service would be very much expected. So where our focus is going to be on looking at the triable aspects of your case. We're going to focus on keeping your record clean, keeping that DWI off your record. If we get to a point where we plea, we're going to focus on maximizing the driving allowances. We're going to focus on mitigating any collateral damage to the case. Again, you want to set clear expectations from the outset so that your client can hear everything that you are speaking to them. So I think that addressing, am I going to jail question, what is the courtroom consequence of the DWI going to look like? That is such an important objection, unspoken or spoken, an important objection to get through quickly, because if a person thinks that they are looking at jail time and you've spent 30 minutes talking about limited driving privileges and you've spent all this time talking about insurance increases and, how is this impacting your marriage? None of that is going to be processed if the person is worried about jail time and they're waiting for you to talk about that. So I like to address the jail question early because it allows a person to hear everything else that you have to say, good or bad. good or bad, if a client is worried about jail time, this is their second or third DWI, they're habitual, they likely know jail time is a reality and a very strong reality. That is the expectation. Now, sometimes where I have seen a disconnect, and so I'll just give a kind of warning on this front. Sometimes where I have seen a disconnect on the flip side of things is somebody calls in with a DWI. They have a kid under the age of 18 in the vehicle, no prior DWIs. And so if you talk about jail time with that client and say, look, we're looking at a level 1, minimum jail time is 30 days. That could be reduced down to 10. The client is really going to have like a mind blown potential situation with that information. So again, you just have to know that going in and just say, look, I'm not going to sugarcoat this for you. Because of there being a passenger under the age of 18 in the vehicle, the consequences are much more severe than a typical first offense. And so we're going to walk through those. I'm not going to sugarcoat everything. We're going to walk through that. But please interrupt me, ask questions, but let's go through this. So you just want to make sure that you're giving the client the best opportunity to retain the information that you are speaking to them. And if there are these anxiety-provoking, unspoken objections, you want to get those addressed early. So, am I going to jail? Obviously, that is sometimes a spoken objection, but more often than not, in my experience, it's an unspoken objection that you want to address. Unspoken objection number 2, am I going to lose my license, right? Freedom to drive means everything. It means being able to get back and forth to work. It means being able to get my kids to school. It means being able to engage in the activities that I want to be a part of. It means being a contributing member of my household. It's obviously huge. So, whether or not a client asks about their license, you have to explain in detail what the suspensions are going to look like that they are facing, whether that's for a potential refusal, the civil revocation, any DWI conviction revocation. You want to walk through those in detail. Again, just like with the question, am I going to jail? No fear mongering and no sugarcoating when it comes to license loss. With a level A1 to 2, I like to focus on the path to reinstatement. So if somebody is looking at a 4-year suspension or a permanent suspension of their license based on a prior DWI being proximate enough to cause a 4-year or permanent suspension, I want to focus on the path to reinstatement. Also, you may want to spend a lot of time focusing on the trial issues. Obviously, losing your license for this period would be severe. We understand that. That's why we are going to look under every rock to determine if there is a path to attacking your DWI conviction so we can avoid those suspensions. So you want to address the objection of a serious license suspension where there's no ability to get a limited privilege from the outset. Maybe that's even the situation with a refusal case, right? First offense, but looking at that 6-month period of no license, you may want to make that a major point of emphasis in terms of we are going to attack the refusal with the DMV. It's an uphill battle, but here's the reality of the situation. We don't have anything to lose. Obviously, if we can keep that refusal suspension from going into effect, you don't have that period of 6-month loss of license, and we're going to do everything in our power to attack that. That may be a client's primary concern, is their loss of driver's license. And so if you say, our plan is to attack the refusal, full force, full send, and no other lawyer has talked about that, huge advantage to you. On the flip side, you got a level 2 to 5 no refusal suspension. And I say level 2 to 5 because now they do have the level 2 LDP for certain level 2 offenders. But if you focus on the importance of a carefully crafted LDP, both pre-trial and post-conviction, you're going to lose your license for 10 days, but from the 10-day point moving forward, you will be able to drive. We will get you a privilege to drive. We are going to make sure that we put every driving need that can possibly be covered into the pretrial privilege, into the post-conviction privilege. We want to make sure that you have full opportunity to take care of your family, to keep your employment, to succeed in life by having freedom to drive. We're going to make sure that we do everything in our power to keep that as open-ended as possible. That obviously is the way to approach it if you've got somebody that is basically LDP eligible for almost the entirety of their DWI case. So those two are consequence-based. Objection 1, am I going to jail? Objection 2, am I going to lose my license? The next 3 are, again, I would say much more truly unspoken objections and are not quite as black and white in terms of how to approach. But next unspoken objection is, do I need a lawyer? And I am going to ruffle some feathers with this answer. No. In fact, 90% of lawyers know less than you about you, the client. 90% of lawyers know less than you, the client, about a DUI since you got one. Most lawyers have zero understanding of what happens with a DUI, so you do not need a lawyer. Now, am I telling people not to hire an attorney? No. But I think if you start off that way, do I need a lawyer? No, you don't. In fact, 90% of lawyers know less than you do. You don't need a lawyer. What you need is a DWI-focused trial attorney. Somebody who is committed to DUI, DWI defense. A lawyer won't do jack shit for you. At least most lawyers won't do jack shit for you. They don't teach you the first thing about DWIs in law school. You don't need a lawyer. What you need is a DWI-focused trial attorney. That's what you need. So I think that's a good way to answer the question, because they're trying to determine, is there value? And when you basically say, most lawyers really not going to add any value, that's why you need to figure out where the value add is. Think about it this way. And again, you don't have to use this analogy in your conversation with them, but you could ask a client, have you ever played poker? So maybe this lands, maybe it doesn't. Have you ever played poker? The person who folds every time will never win. The person who folds every time will never win the poker game. This is why it's so important to me to have an attorney that handles cases to trial on a DWI, even if the client ultimately doesn't want to take the case to trial. Because every person in the courtroom, the judge, the DA, the bailiffs, the clerks, they all know who potentially is the attorney or attorneys in your county that are going to take a case to trial. And if they know that you're never going to try a DWI case, you have no leverage. You have no leverage when it comes to grossly aggravating factors. You don't have any leverage when it comes to other charges being dismissed. And maybe you have a DA that's just like, bends over backwards to make every DWI plea as painless as possible because they just truly on their end don't want to try a case. But to bring the most value into the courtroom on a DWI case, there has to be a threat. There has to be the reality of a case going to trial. That is the person that is most likely to get related charges dismissed, to let them know, hey, I'm going to fight you on the aggravating and grossly aggravating factors, and we'll just take it to trial if that's going to be an issue. If it is a jurisdiction where they might reduce a DWI to reckless driving, or more frequently dismiss a DWI where there's bad circumstances, knowing that you take the case to trial is absolutely going to provide a leverage play with the DA's office. You don't want to be at a poker table when you fold every time, because you are going to lose your chips. So the client, if they are the one backing the poker player and their lawyer goes in and is the one that folds every time, not a good situation. So you do not need a lawyer on your DWI. What you need is a DWI focused trial attorney. And that's what we do, right? Answer that unspoken objection. If the client doesn't ask it, maybe answer it anyway. You might say something to the effect of, you might be thinking to yourself, do I need a lawyer on this case? And the honest answer is no, you don't. You don't need a lawyer on your case. Because again, 90% of lawyers don't know as much as you know about a DUI, because you've been through the process of being arrested, taken down to the magistrate, getting the paperwork. You know more than most attorneys know about a DUI. You don't need a lawyer. You need a DWI focused attorney. Number 4, what makes you different than every other lawyer? Again, sometimes this is spoken. Sometimes it's, I've talked with a couple of other lawyers, or I plan to speak with a couple of other lawyers about my case. So sometimes they might tell you, I'm kind of shopping, I'm looking around. And so what that is saying is, like, I need to evaluate whether your price makes sense in light of what I'm hearing from other lawyers and how much they're charging, what they're telling me. Really what the question is that they're asking, even though they may not know it, is what makes you different than every other lawyer? And you have got to answer this question. Now, your team can help answer this question. If there's somebody else answering the phones, they can start to build up this in the client's mind in terms of saying, oh, you've got a consultation scheduled with Attorney Smith this afternoon. She's amazing. She is constantly handling DWI cases. She took 2 to trial last week. She's in the courtroom every day. This is what she breathes, right? If your assistant is telling the client that before they even get on the phone with Attorney Smith, in the client's mind, all right, this is a lawyer, this is a firm that handles DWI cases. So here's some different areas that might make you different. So, knowledge. Do you teach CLEs on DWI, or attend a lot of CLEs on a DWI? Or focus on DWI at your firm? Is this a focal point, a knowledge point of DWI? So I'm going to give you a little CLE plug. On March 7th, we've got the Attacking Speed in a DWI case CLE at Campbell Law School in one of their ornate, beautiful courtrooms. We're going to be walking through how to attack time distance measurement on speed that officers do, how to use the officer's radar manual effectively in cross-examination, just like you want to use the SFST manual. And think about how many clients call you where speeding is the basis of the stop. If you say, look, I've got the officer's training manual on speed, I know what questions to ask with regard to speed. Whether you say it or whether it just comes out based on the questions that you're asking, you are advancing your unique value proposition, why you are different than any other lawyer to the client. If you know how to attack a speeding stop, I can guarantee you that you are different from 90% of the DWI lawyers that exist. David Goggins has this great quote about he wanted to be uncommon amongst uncommon men. That's why he went through Army Rangers School, the Air Force, Special Forces, and the Navy SEALs training. He wanted to be uncommon amongst uncommon men. Didn't just want to be a SEAL. He wanted to be unique among the unique of the military, right? How can you be uncommon amongst uncommon men and women? You have to continually sharpen that sword, because 10 years ago, you might stand out if you went to an SFST training course, the 24-hour NHTSA class. Now, fortunately, there are a lot of lawyers that have gone through that training. Great for the defense bar collectively. Great for the public to have better representation collectively. But it means that you're not unique just because you went to a 24-hour NHTSA class. That is a great starting point, a great baseline. Every new lawyer at our office has to go through the 24-hour NHTSA class, because without that, you cannot effectively cross-examine an officer. Same thing comes to speed training. You got to know the behind the scenes. What is the officer looking for during their speed stops? How have they been trained to estimate speed? How have they been trained to use their radar device? And how can you cross-examine them on those things in the courtroom to the benefit of your client? So, what makes you different than every other lawyer? Knowledge. Time. Time might be another competitive advantage. You give them a callback guarantee. I guarantee you that I'll call you back within 24 hours, or I send you $100. Right? Now, you got to be prepared to stand behind that guarantee, or else you're going to end up losing money on cases. But basically, what does that callback guarantee say to the client? I will be available for you. So how do you communicate that you're available to the client? Maybe it's, here's my cell phone. Call me anytime. Text me anytime. How do they know that you're available? Maybe it's the amount of time that you spend with them during the consult. I've had several lawyers that tell me outside of our firm that have told me that one of their biggest competitive advantages is they'll just sit on the phone with a client and let them talk indefinitely about whatever it is they want to talk about. Just let them tell their story, let them ask their question, no cutoff, feels like they've got all the time in the world to listen, and that's why they get hired, despite having a hefty fee. Experience. Another competitive advantage, experience. What are the number of DWI cases that you've handled or tried, or your number of years in practice? Another competitive advantage is trust. Well, how do you show trust to a new potential client? You point to Google reviews. That may be the reason that they called you, is because they trust you based on what other people have said about you. If you're asking questions during the consultation about the client's family, about their job, that tells the client, I care about you as a person. I understand that this is just not some sort of bizarre transaction in the courtroom that we are dealing with. This thing has an impact on your life, and I care about you as a person, and we're going to make it right all the way around. I'm not just here to be with you in the courtroom. I'm here to get your questions answered. I'm here to be a guide. Under this question, what makes you different than every other lawyer? Speed. Violence of action. Violence of action. How quickly are you getting on the client's case? What is the framework that you're presenting in the consultation for here are the immediate action items that I am going to take. So, unspoken objection number 4, what makes you different than every other lawyer? You better answer that objection. Unspoken objection number 5 is, how is this DWI going to impact my life? Now, this is a truly, I would say, unspoken objection, because I don't think most potential clients know that they want to know the answer to this question before they speak to you. So, a question along the lines of, what are you most concerned about with regards to this DWI? Or what is your biggest anxiety related to the DWI? You may think it's jail time. You may think it's driver's license. It might be, I'm going to lose my marriage. My wife, my husband has been telling me to stop drinking for years. And when she finds out about this, she is going to leave me. He is going to leave me, right? It might be, I don't want my kids to find out. I am worried sick that my employer's going to find out. I'm in the military and I'm going to lose everything that I've built up. You need to address this question by asking the right questions. So, let the client know that you're here to answer questions as they arise. This is how you help them to give the freedom to think about this and get back to you, right? Because they may not know what is the biggest anxiety point from the get-go. You are the guide. We are here to help walk through the process. If you have a question about anything that relates to the charge, anything going on in your life, please let me know, and I'm going to get you pointed in the right direction. You also, once you have asked a bunch of questions about different aspects of life that could be impacted and whether or not this is causing a friction point or concern, you want to give assurance that a DWI is not going to be the defining negative moment in their lives. I think that answering this question and basically stepping outside of the courtroom and showing, hey, I believe in you as a human being, is so critical. When somebody has been put in handcuffs, they go down to the jail, they have been fingerprinted, their photograph and mugshot has been taken, they feel like a criminal. Their human dignity has been squished, demolished. They feel like a leper. And if you build up their character, you build them up as a human being and say, look, this is not what is going to define you as a person. We can walk through this. Here are the next steps. You've talked to them about what their employment is, that they have kids, what they're involved in the community. You can say, gosh, it sounds like you are a really great person who's made a bad mistake. And I want to showcase that good person to the court when it comes to that. I need to know all of this information about your life because I want to be able to show the judge who you really are. That is going to create that trust. That is going to help build up that person, create that positive emotional connection, that positive bond with you as a counselor that cares about them as a human being and not just as a number. This question of how is this DWI going to impact my life? I think the answer is not as bad as you think it will. Again, not trying to sugarcoat, but our brains are really good at telling us this is the end. This is worst case scenario. This is nuclear. So you have to tell them what the consequences are, but also address that kind of anxiety piece of the question, how is this DWI going to impact my life? By telling them, not as bad as you think. Not as bad as you think. You are going to come through this. You're going to have to face darker moments in your life than being charged with a DWI. And obviously, this is case by case dependent. If there is a death involved in the DWI case, then that is pretty bad. And you've got to have like a different approach in terms of being a counselor in that situation. But somebody that stopped at a checkpoint and blows a .08 first DWI, and they think my life is over because of this. No, it's not. I've represented doctors, lawyers, architects, accountants, people of all different walks of life that have been charged with driving while impaired. It didn't ruin their life. For most people, it doesn't ruin their family. You've got to address that anxiety aspect of a person's brain because their brain is going to tell them worst case scenario. So you need to be the person, again, without sugarcoating, that reassures that this is going to be something that you can help them get through, that they will come out of the other side of this scenario whole. It's an amazing opportunity during that consult to be the guide, to have a life-changing impact on a client. So there you have it. There are 5 unspoken objections that you need to respond to. Can't just respond to the objections that are offered. If somebody says, let me think about it and call you back, that means you did not address their unspoken objections. Means you did not address their unspoken objections. You need to make sure that you have fully addressed anything that could be causing a friction point or a worry about getting you involved on the client's case. Hope this information has been helpful, and I look forward to speaking with you again next time.